So if I said to you, this is a real gain, this is the way I think transactions ought to be. And maybe even transactions are this way most of the time, where the buyer has their agent and the seller has their agent. Now, so let's just pretend like we're playing volleyball. Buyer, Jose works for ABC and showed the buyer XYZ's listing, which is Cameron's individual listing. The buyer says, I want to make an offer on that listing. So let's just pretend like the buyer has the volleyball and the buyer kind of volleyed it down to Jose. So Jose wrote the offer, filled it in, advising the buyer because he's a client. The buyer signed it, and now Jose has it. Everybody with me? They got the signed offer. His job is to get it to Cameron so Cameron can get it to the seller, right? So he volleys it over to Cameron. Cameron has the offer to purchase. It's called an offer. Cameron has the ball. His job is to volley it to the seller, so he's going to present the offer to the seller. So let's say it's here now. So the seller has the ball. The ball's in their court, so to speak. The seller says to Cameron, I love this offer. I'm going to accept it. And Cameron says acceptance means we need your signature. So they accept it, which means they signed it. Everybody good? We have an accepted offer, not a contract. Is everybody good? Because you'll have scenarios and they'll give you some names and different companies. Offer was presented and the seller signed it, and they'll give you some more stuff maybe, and then they'll say the question might be, is there a contract? Or the question might be, when did it turn into a contract? Right now it's not a contract. It's in the second step called an accepted offer. By the way, while it's an offer, while it's an accepted offer, the buyer, Jose's buyer client, can withdraw that offer at any time before the ball's back over here. So the buyer could call Jose right now and say, we want to withdraw our offer. Just because the seller signed it doesn't mean the buyer can't withdraw, because it's not a contract yet. Buyer doesn't know it's been signed, does he? Nor his agent. So I would remember any offer, whether it's an offer, whether it's an accepted offer, whether it's a counter offer, any offer can be withdrawn any time prior to the communication of the signing. Everybody with me? Any offer. Now, the seller signs it, and it's if, as a visual, they volley the ball back to Cameron. Cameron has the signed offer. Accepted. His job is to notify Jose. Until he notifies Jose, it's not a contract. So we want to work urgently, don't we? And so we know we can notify. Let's think about the ways we can communicate. It's in Unit 10, and I'll show you in a minute. Cameron can call Jose, can he? He can call Jose and say, we have an accepted offer, we're under contract. He can call Jose and get voicemail and leave a message, and that passes as communication. Because isn't his voicemail on this side of the net? He can email Jose. It doesn't matter whether Jose opens it. It doesn't matter whether Jose listens to the voicemail. The communication can be to the person directly or to their device. He can fax it. He can drop it off. He can physically drop it off. The whole idea is, and here's the way you'll hear it, the communication needs to get to the buyer in one way or another, in any reasonable way. To the buyer is through their agent. Does that make sense? So to create this contract, this buyer doesn't have to know it's been signed to create the contract. Obviously, we're going to tell him, but to create the contract, because Jose is in the buyer's shoes, because Jose is on the buyer's team, it's a contract when he gets notified. Everybody good? So Cameron gets it over the net, and now we're under contract. If Jose's buyer calls him up and says, I want to withdraw, and Jose says, we're under contract, I was just getting ready to email you or something, the buyer might say, well, I didn't know. And that's when he's gonna remind them, I'm your agent and I stand in your shoes. And don't you think that would have been a good thing to tell him about when he wrote the offer? If I get word at 12 midnight, I might not email you at 12 midnight, but if I get the word, I'm in your shoes.
Okay, let's say the customer calls Jose and say, hey, I
The
don't
client?
want, right, okay, they
Okay.
call me, and they say, I don't want the house, and I call Cameron, and Cameron said, I just received it from the customer side.
Wait, stop. Okay, let's use the right words, client right now.
Okay.
Okay, so this person calls you and says, I want to
Wow.
withdraw.
Yeah.
And you call Cameron
Uh-huh.
and say, I want to withdraw.
But he's already has his sign.
He didn't communicate it though.
Okay.
Did y'all hear Jose's question? The buyer calls Jose and says, I want to revoke my offer. And Jose says, well, I haven't heard it's been accepted, so let me notify. We're notified over here. So Jose calls Cameron and says, Cameron, my buyer wants to withdraw the offer. And Cameron says, I've got it, it's signed. Too late. You didn't tell me. Until it is communicated, it's not a contract. Now, I bet you things could happen like that in real life, and you gotta know how it works. You gotta know, you didn't communicate to me. Until you communicate to me, if I'm his agent, if it's Jose saying, you didn't communicate to me, and I stand in the shoes of the buyer, so no contract was created. If you pick up the phone and call Cameron, and Cameron says, oh, Jose, thank goodness you called, we are under contract. It's too late for you now. Yes, sir?
So what if, so say Jose called Cameron and Cameron was like, oh, we got the offer, but he's like, okay, we're not in contract. Can Jose go back and tell his buyer, instead of dropping out, they got the offer ready? Can he still go back and do that?
Oh, yeah, because technically the buyer can't withdraw.
Okay.
So Haman's question is, Jose calls Cameron, and Cameron says, oh, thank goodness you called, I was getting ready to call you, we're under contract. Haman's question is, now Jose, what's he gonna do? Can he call the buyer and tell him it's too late?
No.
Oh,
No.
Oh.
I was saying, like Cameron has got the offer from the seller.
got the signed offer.
Right, but he hasn't dictated yet, so he's like, so Jose's like, we want to cancel because you didn't give me a contract yet.
Yeah.
Can Jose go back and be like, I know we just said no to them, but they have the offer ready?
No,
No?
well, it's canceled.
Okay.
Haman saying sure he could, but the whole idea is when did it turn into a contract? If Jose called Cameron and says we want to withdraw, and Cameron says, well, I've got it signed, well, we're withdrawing. Jose could say, well, let me call the buyer and just see if they want to change their mind, but at this point, it's withdrawn.
Okay.
And it is because Cameron did not communicate first.
Gotcha.
It has to be communicated. That third leg, that third step has to happen. Okay? All right, let's do it where the buyer's a customer. Guys, this is an interesting one. All right.
So, Miss Jan,
Uh-huh.
and this might be just,
What?
I said this might be just a simple question, or silly or whatever, but, so it's really just whoever speaks up first? Is that
Yes,
simple
ma'am.
in real practice? And that, okay. So what if, say for instance,
Now, in real life, hopefully that doesn't happen all the time.
Yeah.
But, because more than likely, Cameron would have emailed, and and as soon as it hit his email, it's a contract.
okay, but that's what I'm saying, like, what if they, just like you just said, email, or he said, he left a voicemail, but for some reason the agent didn't get it.
Doesn't matter.
Right?
Doesn't matter. Didn't mean to stop you so shortly, but we need to know, don't matter. Did y'all hear her, did you hear her question? She said, what if Cameron left a voicemail on Jose's phone, but Jose didn't pick it up, and Jose calls and says, we want to withdraw? You're gonna keep real good records, and Cameron's gonna say, I left you a voicemail at 9:00 p.m. We're under contract. Yeah, so voicemail does count. And if he says, I don't have a voicemail, I mean, it could be a he said, she said, but voicemail message counts. Mhm.
So, I'm not trying to confuse anybody else again,
Okay?
but what if like Jose's phone like broke and he sent the voicemail?
I don't know. I don't know. But my pay grade. I would imagine the intent, remember what the law said, the intent was, we left a voicemail, we didn't know your phone was broken.
Okay.
I would still think it'd be communicated. All right, in the buyer and the seller on opposite ends, no matter who has an agent or not, they're playing a game here. And the buyer's on his team and the seller's on his team. Let's say, let's use somebody else. Kate is talking to the buyer. And let's say Justin is talking to the seller. All righty. Kate, well, let's do this side first. Seller hires XYZ, and XYZ hired Justin. Everybody good? So Justin is an agent to whom? XYZ. Only time, guys, other times you're a sub-agent. This is really the only time you're technically called an agent. When we're looking at technical, I know we call ourselves agent in the field. That's okay. But this is the only technical time he's an agent. Agent of an agent. And so we know the firm is the agent. So everybody good on that? All right. Kate's talking to the buyer. She's got the Working with Agents brochure, and she reviewed it with the buyer. And part of that brochure's purpose is review it, explain it, and then determine how are you going to work, Kate. Are you going to represent the buyer, or are you going to represent the seller? Because we are an agency state, you have to work for somebody. We're not non-agents. We are agency. Kate talks to the buyer and asks the buyer, would you like for my company to represent you? And the buyer says, no, I don't want you to represent me. So Kate is making sure she understands. In other words, you want to remain unrepresented, and we call that a customer. And you understand that if I don't represent you, I have to represent the seller. Do you understand that, buyer? And the buyer says, I'm okay. So Kate has to represent the seller, as long as XYZ will co-broker that way. You know, the listing company can say, we don't want you to represent our seller. In your reading, do you remember reading something called vicarious liability? In unit maybe 8, vicarious liability means if agents are representing the seller and the agents misrepresent or make a mistake, the seller could be held accountable for that because they hired the company that hired them. In other words, if Megan messes up, I'm the one responsible, right? And so that's what vicarious liability means. So a lot of listing firms say, we would rather y'all be on y'all side and we'll stay on our side. And so oftentimes you see an MLS where the listing company will have an MLS, buyer agents only. We don't want you representing our seller. We'll do that. Thank you very
What would
much.
be a reason a customer doesn't want to be represented?
I can give you 3. They don't trust you. They don't want to be tied down to you for a long time. And they don't want to pay commission. And they're afraid of all of those. So my opinion is we need to overcome that. If they don't trust you, and you can imagine meeting somebody at the beginning, maybe you have some letters of testimony or some names of other people that have worked with you, or maybe you sell your company. Here's our company. We're well known in the business. Maybe you don't know me, but it's my company that you're really hiring, right? So you got to overcome the credibility, trust. The other thing is, I don't want to be tied down to somebody. Well, now let's just sign it for today. I'm good with that. Till you get to know me. If you want to just sign the buyer agreement today, we're cool. I would do that if somebody's having a hard time. I'm not gonna do it for indefinitely. I'm gonna say, I'll show you a couple of houses today, and then we'll regroup and talk about it, because this is the way I make my living, and I would like you to commit to me, because I wanna commit to you, right? The other is about paying the commission. Let me show you where that is in the book. Go with me to 202. Wasn't that where the buyer's agreement was? Now, you would think if the buyer hires the company, they ought to pay the commission, but they hardly ever do. So go with me to page 202, and go with me to number 4, because this is an agency agreement. You have to talk about how you're getting paid. So if you look at number 4, let's just go to 4B. 4B, buyer agrees that the firm's fee will be X amount. In other words, buyer, when I sell you a house, our company needs to get paid. No matter who pays it, we need to get paid. And so you would put in that line whatever the percentage is that your company expects on the sale side of the property. You know, if you sell the property, if the total commission comes from the seller, if you get a listing agreement, you might get the listing agreement for 7%. If you sell the property, you get part of that. And so whatever part your company says we need to be getting when we sell property, it could be 3%, 3.5%, whatever it is you think you ought to get when you do the sale side, that percentage will go here. It wouldn't be the full commission though, because you're not doing the total job, right? Look at B1. Take a minute and look at B1. It clearly says the firm will seek the fee from the cooperating listing firm through MLS. So we are going to be paid through MLS, which comes from the listing firm, which comes from the seller, right? And then it says if it's not listed, we're going to ask the seller to pay us. We're not going to ask you to pay unless, in the very rare case, the seller doesn't pay. If it's listed in MLS, you will be paid from the listing firm if you sell the property. And that comes from the seller, right? So there shouldn't be any issue with that. I had one time in my career where my buyer client found a for sale by owner. The for sale by owner is a customer, you all said, right? So that means my buyer has to be a client, because we have to represent somebody, right? He was a client already, but he wanted to see this house, and he already decided he wanted to buy it and hadn't even seen it yet. So I called the seller, because I told the buyer in the consult time, I told the buyer, if you're riding around out there and you see anything, call me, because you need to work through me, because I expect to be paid. We're contracted together, right? And so if you see a for sale by owner, call me, because this agreement says if you buy anything while you're in contract with my company and me, we're going to get paid one way or the other, right? And so this buyer calls me up and says, we found a for sale by owner. Here's the address and here's the phone number. And I said, thank you very much. I'll check into it and see if we can make an appointment. I called the for sale by owner. Said, I'm Jan Secor. I work for Prudential then, which is Berkshire Hathaway now. I work for Prudential Real Estate, and I have a buyer who would like to see your home. Would you allow me to show your house? She said, yes. Luckily, I didn't forget this next question. Next question, will you pay my company the sales commission? And she said, no. I was taken aback, to be honest with you. I didn't want to hear no, because I know what no means. No means I got to go back to the buyer and say, we got to be paid. I asked the seller, because I told you I was going to ask, and they said no. This is a rare case where the seller said no. Most for sale by owners will pay a selling broker. You know, they'll pay whoever sells the property. But she said no. So I called the buyer and I said, remember, we talked about this. If I ask the seller and they say no, which a for sale by owner can, MLS, we know we're gonna get paid. It's a cooperative, right? Do you still wanna see the property because we're gonna ask you to pay the commission? That would be the rare case. And let me tell you, in hindsight, I would have rather not asked for that because I never heard from them again. They bought the house and they paid our company. The whole thing changed. The whole warm and fuzzy went cold as ice. They did not like paying the commission. And, you know, we build our business wanting people to come back to us and send it us. I never heard from them again. That was not my decision to say I'll work for free. And why would I want to work for free, right? It wouldn't have been my decision, it would have been my company's decision, because doesn't the company get part of everything I do? It all runs through the company, but we had to be paid. They didn't like it, even though I explained it to them. Couldn't they have said, let's go find another house?
Yeah.
Couldn't they have done that? Couldn't they have said, well, let's offer them more so they pay it? We don't want it coming out of our pocket. But as it turned out, I doubt that even happens 1 in a trillion times. But the whole point is, if you've got a buyer client in this agreement, you do ask the seller or through MLS to pay you, and the odds of me coming back to ask you buyer are slim to none. And even if I do, you can say, no, let's don't look at it, right? So that is a fear. Did you have a question?
Yeah, but they would have the issue, or the same issue if they went to anyone else, right? Because even if another.
Except they could go to the for sale by owner. If they went to the for sale by owner, if I have this agreement with them, I'm still entitled to my commission. Because it says if you buy anything while you're in contract with our company, we are entitled to commission. And yes, they would have had the same issue. But guys, what's wrong with making a commission? I mean, we shouldn't be ashamed or embarrassed about it. It's how we make our living. Your own straight commission.
How
LaToya?
much was the commission?
Much.
Because they didn't want to pay it, so I was like.
Really and truly, it was only about $1,600. It wasn't huge. But still, buyers are not accustomed with pulling that out of their pocket and paying. Buyers are saving for down payment. And you know what? More than anything, it was probably the point. They just didn't think they should pay it. Personally, why not, buyer? You hired us. Seller pay their agent, buyer pay their agent. Now, buyers can argue. We are paying the commission by buying that house, right? Because the commission comes out of the sales price. Anyway, somebody else? All right, let's get back to this. Kate talks to the buyer, and the buyer says, I don't want to be a client, and Kate makes sure he knows what that means. So here's what it means as a visual. Kate's not on his team, because he doesn't want her on his team, right? Kate and Kate's company comes to this side of the net for this transaction. So ABC and Kate are over here. ABC is broker to XYZ. They're called agent to agent. Because isn't this a firm broker and they're a firm broker? That's called co-brokering still, right? Kate is an agent to ABC. She becomes a sub to XYZ for this transaction. She's not an agent of XYZ, is she? Did XYZ hire her? Not directly, did they? ABC hired her. Remember I said you're only an agent one time. You're an agent to the firm that you work for. So because she's an agent of an agent, she's a sub to that company. So she's representing that company who's representing the seller in this transaction. Well, because she's a sub to them, she's a sub to the seller too. ABC is a sub to the seller too. ABC is a sub to the seller because they're an agent of an agent. So everybody on this side is looking out for the seller. Has anybody got any questions? That looks like John Madden football stuff, doesn't it? The whole point is, the real estate individual people are agents one time, and they're an agent to their firm. And they're going to be a sub-agent to everybody else. Does that make sense?
That doesn't mean that she's gonna get the commission.
Oh yeah, the commissions, Guys, the commission has nothing to do with buyer, client, buyer, customer. They still are another company, and if they sell the property, they get the sale part of the commission. ABC didn't merge with XYZ. XYZ, huh?
A little bit of an emergency, whoever owns the green expedition outside, you were just hit by a car, and they're still in the parking lot now, witnessed it.
Oh, who owns that green Are you kidding?
Is the car next to it okay? 'Cause that's my car.
Why would they, how could somebody hit something?
The car rolled back, I don't even think it was on, sorry. I just
You're
didn't want
fine,
people to
definitely.
be,
Good thing you were out there.
Yeah, for sure.
They sure probably would have peeled out a little bit.
I saw Cameron's face, and I'm thinking that's.
It is Cam, I think I've seen Brandon's eye.
Yeah, Cameron and then Ian Park.
Ian Park's next to him, I believe.
Okay.
I didn't
Well,
mean to interrupt you.
okay, well, let's go on, everybody. All right, so now just look at this for a moment. Look at the visual. You know what? This will help you on your test, I promise you. And the other thing is, if you're trying to explain to a buyer, if Kate's trying to explain to a buyer, you need to be a client, I would draw something out like this. Because buyer, you're playing this game all by yourself. Who's going to win?
You're gonna get killed.
You're going to get killed. All those linebackers are going to come get you because how can you represent yourself? It reminds me of going to court, these Law and Order shows, and the judge says, huh?
His car is okay. The other car's beat.
Whose car's okay?
His car's okay. My car's fine too.
Well, how could the other car be beat if his car's okay?
So
It's a big car, I don't know.
Um,
I totaled one last year, so my parents would kill me if something else.
We won't tell. All right, so guys, do you get the visual? Buyer, you're playing this game. Think about it that way. This is a match. Think about if you were in court and the judge says, who's your lawyer? Your Honor, I'm gonna represent myself, and if I'm the judge, I'm saying you're gonna lose. Get yourself a lawyer.
So
Get yourself an agent, you're gonna lose.
So Kate's involved in this because she brought the buyer to.
Yeah.
Okay.
All right, so let me say what I want to say to that. You can show houses to buyer customers, and you can sell houses to buyer customers, and you will get the sale part of the commission. Buyers don't have to be clients for you to sell them a property. Guys, you need to remember that. That's the way we worked in the olden days before 1993. Buyers were always customers. There's a selling company and a listing company. So this is agency, is what we're talking about. And you gotta know agency to know when did it turn into a contract. So there's still two different companies, and XYZ gets the total commission, and they co-broker with ABC and they get the sale commission. Guys, commission has nothing to do with your agency. And that was even in your book somewhere. It says compensation, agency does not affect compensation. If you sell the property, you get paid no matter if the buyer's a customer or client.
Because you brought in the customer regardless.
You brought in the buyer regardless,
Right,
right? You brought in the buyer regardless. And if you bring the buyer, and if it meets the terms of the seller, you should be paid.
So, okay, I'm sorry, I'm just trying to put this into, because all the wording. So, I meet somebody and they wanna go look at houses, but they don't want me to be their agent. I'm taking them around, they like the house ABC over here. And so they decide they want me to help them.
Write the offer.
Offer for it, but they still don't want me to be their agent.
They don't want you to represent and advise them.
Right.
They want you to write the offer on behalf of the seller.
Okay, and then so it all works out, they close, and I still get a piece of that commission.
You
even though I
get,
wasn't-
the commission is divided in half first, let's say for illustration. Your company gets their part and they pay you.
Okay,
The commission still, guys, when we do commission, there's somebody brought the seller and somebody brought the buyer. There's a listing part of the transaction, and there's a selling part of the transaction. The selling part has nothing to do with if the buyer is a client or a customer. You found the buyer. Let me show you on, let's look at something real quick. go with me, and that is something students are confused about. For some reason, we think that the buyer has to be a client in order for us to sell the house. No. You have to know at the very beginning, first substantial contact, do you want to be a customer or client? I'll still work with you, and I'll be happy to write the offer up. I can't advise you on it, and I'll present the offer because our firm will still get the sale part of the commission. Most agents probably are buyer's agent, but this could let me give you an example of when this happens, and I'll get your question. What if you go to an on-site new home construction? Those agents on site are not going to offer to be a buyer's agent. Won't they write an offer though for the buyer? And they'll present it to the company, and they're going to get paid the sale commission. So there are companies, on-site new development is the best example. They only represent the seller. Yes, ma'am.
Would it be good to offer them the non-exclusive buyer agency agreement?
Anything, they need to be convinced to be a client.
They're still
And-
compliant with that, but then they're not as trapped in with you, so they don't feel, I mean, you know, some people.
No, I don't know. I don't know what you said. She said they're not trapped with you.
People are nervous about doing, you know,
I know.
buyers especially, you know, and so that gives them the freedom to do something else if they feel like it, but.
And as an agent, I wouldn't want that kind of an agreement with my buyer. But it would be better than nothing. And so, and for them, it'd be better, at least you can advise them because that's the best way for them.
Right.
And if you know they're worried about the commission, if you can't convince them otherwise, yes. She's bringing up, remind me your name. Who? Amber. Amber, I apologize. I didn't remember a lot of people because I just got back. I have not been on vacation, but you're a lucky duck because I didn't even have you counted out. I didn't even have you counted out. Amber's asking about the non-exclusive buyer agency agreement. Let's just find that real quick. In your agency contracts, there's an exclusive buyer agreement and there's a non-exclusive, and that would be an alternative. She's exactly correct. If the buyer's just afraid of being committed to you, you could say, well, here's another way we can do it because I think it's in your best interest. Where is that? I see, there should be the non-exclusive in here too. I remember seeing it.
Oh, here it is,
What page?
39.
239. Go to 239, everybody. And what Amber's bringing up is legitimate. There may be buyers that just don't feel comfortable with being tied down, being in, even if it's for a month or two. They just don't want that. And they still just sort of don't believe they're not going to be stuck with the commission. I mean, that's kind of what they might be thinking. Look at page 239. This is non-exclusive, Amber said, which means you can go work with any other agent you want to. But if I show you a property you buy, this is my proof of agency that I've earned by commission. But if you go to, where does it say it? Look at number 3, compensation of firm. This agreement does not obligate the buyer in any way. So right there would appease them too, wouldn't it? If that's the hang up, wouldn't that appease them? You're not obligated in any way. Now, I know agents who use this form, and here's why they tell me they use it. They say, I don't want my buyer worrying about paying me, and so I'll use this non-exclusive. I trust the buyer, and my advocate question is, well, then they're not loyal to you, and you can be shown a lot of property, and they go find something else that you didn't show them, but they're not loyal to you. I trust my buyers. Well, okay. I trust my buyers. I get that. You know, we build business, we build the loyalty, but guys, I get it.
Time is money.
Time is money. And then, here's one thing I have heard, and I'm going to be a little smart aleck about it. My next question would be, and these are to brokers and CE or something. My next question would be, so you'd be willing to work for free. Yes, I would be willing to work for free. Now, I think that sounds a little silly in a way, and now here's my smart aleck response. It's not up to you. It's your company. Doesn't your company want a cut of everything you do? They're not gonna want you out there working for free. At least they're gonna want their cut. But your point is well taken. This non-exclusive would appease a buyer who's just afraid of some things. Let's get back to this. Thank you for that. And one more, yeah.
So when, so Kate writes that offer for the buyer,
Uh-huh.
does she bring that to me in this?
I'm gonna show you.
Okay.
All right. Kate is in agency on this side of the net, right? But she's over here, the buyer's not writing the offer, ever. Kate's writing the offer on behalf of the seller. So she's being of service to the buyer because she represents the seller, right? If you go to a department store, you're getting customer level service. Aren't they trying to sell the products that the sellers want them to sell? Okay. So Kate's going to write the offer. As a visual, it's like the buyer has the ball. It's in his court now. She wrote it. But as a visual for determining a contract, the buyer, let's just visualize, so I'm going to use a different color here. We've got it over the net. Kate has the ball now, or the offer. Everybody with me? It's almost like the buyer got it over the net to Kate. Kate was of service and filled in the blanks though. So Kate has the offer, but she's over here already. Everybody with me? So she's got the ball, she's got the hot potato offer. She takes it to Justin. She is not going to contact the seller, even though she's a seller sub. Isn't he the individual seller sub who went out and prospected and got that business?
Yep.
So she'll get the ball to you. Does that make sense? It still has to go through the chain of command, if you will. Justin has the offer. He takes it to the seller. Seller says, I love it, Justin. I'm going to accept it. Accept, we know, means signed. So the seller has signed the offer. When they sign it, Justin's got the ball again. Everybody with me? We know it's not a contract, right? Justin's gonna, we got a game and we're volleying back and forth. You see him on TV. So he's volleying it back to Kate. Kate's got the accepted offer now, right? Justin is not gonna call the buyer either. Because when we work with realtors, we cooperate with them and we're not gonna we're not gonna go directly to their clients. Everybody with me? That would be a code of ethics violation. When they're real estate agents, we go through each other. Justin calls Kate and says, we have an accepted offer. That's what it is, right? Until Kate notifies the buyer, we are not under contract. Kate has to get the ball over here some way, somehow, to the buyer because he does not have an agent standing in his shoes. Communicating to the buyer, she can leave a voicemail. She can email. She can drop it off and give him the physical copy. She can fax it to the buyer. It's got to be communicated to the buyer. Now let me give you a scenario. Offer comes in. Kate is a seller sub-agent. She takes the offer to Justin. Justin presents it. It's signed. Justin calls Kate and says, we have an accepted offer. Justin's going to say, let me know, Kate, when you notify the buyer so we'll know when it's under contract. 2 hours later, Kate calls Justin. I can't reach the buyer. I'm going to be biting nails because we're not under contract. We're not under contract, are we? So what that means is the buyer can call up any time and withdraw. So does it make sense that Justin's going to say, call me just as soon as you notify? Because we are not under contract until that happens. Here's what could happen. Seller could call Justin and say, I want to withdraw my acceptance. It's not a contract, is it? Hold on. Are y'all with me? Anything can happen until we turn it into a contract. Anybody can withdraw. Seller can say, even though I signed it, I want to withdraw. I've rethought it. And if it hasn't gone over the net to the other side, it's revocable.
She can't send it over to connect with, to the buyer with the email or voicemail?
Not when we are realtors, we don't. The question is, can Kate just can Justin or the seller contact the buyer? What was your question?
So
Kate can, yeah.
Yeah, but she said, you said Kate called Justin. And
No,
said,
I
"Can't reach
redid the
buyer."
scenario. I redid the scenario. I said, another scenario, Kate's trying to reach the buyer and can't reach them.
So that means she didn't leave a voicemail or anything along those lines?
But she could leave a voicemail. Or
And it would be communicating.
Okay.
Does,
I don't know about you, but I've called people, I've called students and get their, the message, and it says, voicemail's full. This voicemail has not been set up, right? And so she could have left a message. I'm saying she didn't in the second scenario, and if she didn't communicate, we are not under contract.
So if you communicate by mailing?
Yeah, I'm gonna show you that in a
Does it have
minute.
to be certified?
No,
No, okay.
hold that thought on the mailbox rule, I'll show you that. Jose?
quick question, does Kate have to be a closing date for the buyer? If she wasn't,
What now?
does Kate have to be, you know, when you go close?
To a closing?
Uh-huh,
Kate has to be at the closing, but it's not for the buyer, it's for the seller.
okay.
When you are in agency, you go to the closings, and she's not representing the buyer, but doesn't she represent the seller?
So
She goes to the
I
closing.
got you.
She's gonna get paid. She needs to look at the closing statement and make sure all the numbers are right.
Correct.
One more question, we need to move on.
As long as you have documentation that you tried to call the buyer, but his mailbox was full,
Doesn't matter?
is that notification or not? Okay, that's not.
Not. You have to reach the buyer or the buyer's agent if they have one. I've tried and tried, and in this day and time, that doesn't sound like a good excuse though, does it?
Right.
But if you get a test question and it says, Kate can't reach the buyer, are they under contract? And the answer's no. And if you wouldn't know that if you didn't understand Kate's not on his team. So this agency and contracts goes together, seems like to me. Everybody sort of okay? All right. Let's do one more real quick, and then I want to do a few, I want to see if we can finish up Unit 9, which we can. All right. XYZ is the agent. Seller hired XYZ. Everybody with me? So XYZ is the seller's agent. Jose works for XYZ. Because Jose works for XYZ, he's a sub to the seller. Everybody good?
Yeah.
All righty. Cameron, Cameron found a buyer and the buyer hired XYZ. So the buyer says, I want to be a client. And so XYZ is an agent to the buyer and Cameron is an agent to XYZ. Cameron is a sub to the buyer. Everybody see that? That's not dual agency yet, might not ever be. Can't we have lots of seller clients and lots of buyers clients in one company? That doesn't mean it's always dual agency. The only thing that would make this dual is if Cameron wants to show Jose's listing. If Cameron show another company's property? Guys, this isn't dual yet. Are you good? Dual takes one agent, which means the firm. It takes one transaction or the showing, something that leads to a transaction, and we don't have a transaction yet. So that's not dual. Everybody good? Having two clients doesn't make it dual. John, you good? Having two clients doesn't make it dual. We need a transaction or a showing, something where you're acting like an agent. All righty, let me show you something else. Now pay attention here. I'm going to use a different color. Jose is an agent of XYZ and is a sub to the seller. Jose is an agent of XYZ. He's a sub to the buyer too. You're a sub to any client that hires your company. Does that make sense? Cameron is an agent of XYZ, and Cameron is a sub to the buyer. Cameron is an agent of XYZ, he's a sub to the seller too. Looky there. It's like crisscross applesauce. I visualize sitting Indian style, and I can't ever do that in a million years anymore, but little kids do, and you say crisscross applesauce. So that makes it complicated, doesn't it? Dual agency is more complicated because it looks like a conflict of interest. That's why we've got to talk about it and make sure everybody's good to go on it. So what that means is if Cameron wants to show this property, he is neutral. We go in the middle, and Jose does too. You have to be neutral if you're representing both clients. The company's neutral. Right? They're representing both clients. How can they favor one or the other? Well, I can tell you perception is reality. And I can tell you that buyers and sellers sometimes think you favor one or the other. It reminds me of my boys being little. Here's 2 cookies. Mama made chocolate chip cookies. Here's you one. Here's you one. Mama, his cookie's bigger than mine. Perception can be reality, can it? So when you're in dual, you have got to walk the fine and narrow because you've got to be fair to both parties. It's almost like you've been neutralized. You can't favor one or the other. You are trying to make the transaction happen. You're passing the information to the other. So you do not advise. When Cameron's buyer wants to make the offer, the buyer might say, well, what do you think, Cameron? Cameron says, I'm not thinking right now because I can't advise you. You tell me. Offer is presented to the seller, and the seller says, Jose, what do you think? Jose says, remember, we're dual. I cannot advise you on this. It's your decision. I'm presenting it, though. We're trying to make the transaction happen, and my company's representing both of you. We got to stay neutral. So, offer comes over, well, it's kind of like this. Cameron has the offer and takes it to Jose. Jose takes it to the seller. The seller says, I accept it. Whose shoes is Jose in? Whose shoes does he stand in? Seller and the buyer. Isn't he in the middle? Didn't we say he's a sub to the seller and the buyer? When you're an agent or a sub-agent, you stand in the shoes of your client.
So you're in contract.
You're in contract.
But if you
Under dual agency, you're in contract as soon as the seller signs it, because Jose really represents the buyer too. Now, obviously, he's going to contact Cameron, but the question is, when is it a contract? And in dual agency, or if it was dual designated, when it's accepted by the seller, no changes, it's a contract because you're on the line in the middle and you represent, or your firm is, and you represent both clients at the same time. Everybody good? Okay. This is contract questions. You got about 5 of them.
So,
That's complicated.
Huh?
briefly, so if you was in the same agency, then you can advise the customer about the offering?
Right.
Okay.
It's almost like, I think Jose might be saying, it's almost like you're treating them like they're customers in a way. I mean, you've gotten zapped. I mean, you can't favor one or the other, so it's almost like they're customers, except for you can't give confidential information to either party, because that would harm one of the parties. So it's almost like you're acting so neutral as if they're are a customer. Mm-hmm.
So if the buyer wants to, so if the house is selling for one price, but the buyer says this is all out offer, you're just okay, that's fine, they have to.
I might not say it, yeah, that's it.
Yeah, exactly, you can't advise them and
That's right.
negotiate whatsoever.
If the buyer says, let's say the house is listed for 100, and the buyer says, I want to offer 95, what do you think? And, well, full price would get it. You could, full price is, you could say that, couldn't you? But you can say, you know what, I can't give you advice on that, but I'll be happy to present it. That's what you say.
But as soon as they say 95, don't you have a disclosure to tell the other
You gotta present the offer.
No, but I mean, what if they're like, hey, Hamad, I wanna offer 95, what do you think? But I'm like, I can't say anything about my thoughts because I'm in the middle. But as soon as you get that they say 95, isn't it your job to disclose to the other?
It's not an offer yet.
Okay.
It has to be an offer.
Okay.
Yeah. And so you're talking about it, if they say, let me take your question and take it a little further. What if the buyer says, okay, they're asking 100. I wanna make 95, but I don't wanna lose the house, I'll pay full price. Here's what I'm gonna say. You've done it now, I gotta go tell. You shouldn't tell me when I'm in dual what you'll offer, right? And so you really shouldn't tell that because you represent both clients, okay? All right, one more question, we need to move on.
So as a buyer, on that document that you have to sign, that you're becoming into agency with the agent. So it's in your best interest to say, I do not want to do a relationship.
Whose best interest?
The buyer.
No, why are you saying it's in the buyer's best interest?
Because it seems like, yes, I found this house I like, and it's listed by your firm, but you're really not on my side. You're in the middle.
But I'm not on the seller side either.
But you can't really advise me. I feel like I would be losing.
But the seller is in the same boat. We can't advise either one of you. So I can't favor the seller or you. I get her question. If we're in dual, I'm not getting any advice. That's why some companies say we have this alternative called dual designated. If the company offers it, well then, and if the clients want it, then Cameron gets out and Jose gets out, and then you advise the client as if the dual never happened. So if the company offers dual designated, you get out of the middle and you're exclusive again. But if the company doesn't offer dual designated, they're too small of a company, they don't have enough agents, well, I understand what she's saying. The buyer says, well, it's like I don't have any representation anyway, but think about it. At least we're not all favoring the seller.
Right.
That's it's better to be neutral than all of us ganging up on you because we favor the seller. I mean, I understand what you're saying. No representation isn't good, but neutral is better than nothing. Because if you're neutral, is everybody follow me? You can't favor the seller either. So the seller's not gonna get the benefit. So we're treating you both the same. Let me just mention one thing. Guys, it seems to me when you meet a buyer at the beginning, if you're not meeting them on a cold call, doesn't it seem like you ought to spend some time with them and explain how all this works and talk about what the market's doing? Don't you think you should give them advice before any of this happens? When you meet with a seller, don't you give them advice like a CMA and help them before it even happens? So my point to you is they should have the knowledge already. And it's kind of like the little birdie in the nest. They're ready to fly the coop. They're ready. And the buyers and sellers make their own decisions anyway. But I'm going to educate the buyer before we look at a lot of houses. I'm going to say, here's what houses are selling for. Here's what's going on. Here's the process. Here's everything you need to do. So when we get to this point, they're not like, what do I do? We should have had a conversation and a meeting about that before, is my opinion.
So with that being said, if they're like, hey, I want to offer this for 95, can I say at least, hey, so the house down the street, so?
No.
No? Okay.
Not
Well, let me not be so harsh on the no. You can give them facts. You cannot compare the facts.
Okay.
So if the buyer, you can say, here's a list of what's sold. I cannot compare it like a CMA though. I can give you the facts and you look at it. I can tell you what else is listed and you look at it. I cannot, just kind of like a customer, I just cannot manipulate the numbers because that's kind of helping you, right? Uh-huh.
So on the test, either yours or the state test,
Yeah.
is it going to ask us to, is it liable to ask us, when does a dual become a contract versus when does
It won't be just like that. It'll be a scenario. It's going to be paragraph form scenario. And it'll say, like those three scenarios. There's a listing agent, Jose represents the seller, Justin represents the buyer, buyer makes an offer, Jose presents it, it's signed, and it's gonna give you the scenario. But it also could say, the scenario, Jose has the listing, Justin works with the buyer, and offer is presented, offer signed, blah, blah, blah. Is it a contract?
So
It could be Jose and Cameron work for the same company, offer presented. It's gonna be like what I'm showing you.
So when the seller accepts on a dual contract, you know what I'm saying? And so when the,
But do you understand why? When the seller accepts and the agents are in dual, it's a contract as soon as they sign it. Do you understand why? God, you know what? I really believe if you can understand this instead of just memorizing it, if you really kind of can look at it, tell me why. I'm not trying to put you on the
no,
spot.
I get, and I'm trying to walk back to
Okay.
the wording right. Because you're neutral, so you're not really on either side.
You're on both sides.
Well, you're on both sides, but you're not pitting each one against each other. So
Okay.
you proposed the offer and you presented it to the seller, and so
When the seller signs it, it's a contract because you're in sub-agency to both clients. That's why.
Work for the same firm.
You work for the same firm and you represent both clients.
But I don't understand, I get that in my head, but I don't understand why you wouldn't have to go back and say, okay, buyer, he accepted you.
You don't have to. You will let them know you're under contract. But if the question is, when did it turn into a contract? Because you are an agent, you are like a buyer.
Because you know, and
Yes.
you're
Yes.
standing in the buyer's shoes.
That's right.
Okay.
Standing in the buyer's shoes and standing in the seller's
And
shoes.
so as an
In
agent of the
dual agent.
buyer, you know, and so therefore it's.
That's
you're
right.
notified. Okay.
That's right.
Okay.
So a designated dual is not as soon as Jose knows. He has to let Cameron know.
No. Justin said, and I know I'm stopping y'all short and I don't really mean to, but Justin said, what if it's not dual in the middle? What if it was designated? Would Jose have to call Cameron? No, because the firm still is the one and only agent. So you're still in dual. Guys, dual, designated is a form of dual. So you're still in dual. So if it's dual designated and the seller accepts it, it's a contract too. And it's because one company represents both. Okay, real quick. Mhm.
I really urge everybody, if you're not reading your comprehensive exam questions, they are wordy like she's saying, and they are in the back of every chapter of your book. It will show you how the ball goes back and forth, and it's very deliberate on how it answers the questions. That chapter 7 also shows her diagrams on sub, on dual, on designated, and the reason these exams are comprehensive. So use those questions to get used to answering those questions. I know it's a lot, but the questions she's giving you, she's preparing you, but the book is giving you the wordiness that you're gonna encounter. So if you're doing those comprehensive exams and she is presenting to you her diagram, you should be able to interpret it to a certain extent.
You know,
Those
that's-
comprehensive exams.
That's the thing of level 3, we do have to be able to interpret and really have the understanding. And I know when I ask you to tell me when you're on the spot, it's harder to say, and I do get that. But I think if we can talk and if we can just kind of see it and understand it, it's better just saying, instead of saying, well, sub-agent means this. If you actually see what it means.
Yeah.
Guys, go back to page 259. Let's see if we can finish up this unit 9, because it's only 9 pages, and we're only on page 1. Lord have mercy. All right, just real quick. Just knowing some terminology, express contracts and implied contracts. Express means words. An express contract is worded. Express can be verbal though, and express can be in writing. Is everybody with me? Didn't we say a buyer agency contract can be verbal? So express, you're expressing verbally or you're expressing in writing. Implied contracts are implied by the action of someone. In the olden days, you could drive up to the gas pump and pump your gas and then go pay. You're implying that you're gonna pay it. Not anymore, because people drive off, don't they? All right, go to the next page. Bilateral and unilateral. Bilateral contracts are promises for promises, kind of like a sales contract. A bilateral contract, one person promises and the other person promises, like a listing agreement. The seller promises, the agent promises. Most real estate contracts are bilateral. Now in Unit 10, they talk to you about an option contract. And option we'll speak about on Wednesday is a unilateral contract. And it's because only one person is promising. Executed and executory. I'm on page 260, everybody. Executed and executory. An executed contract is done. It's closed. I gotta tell y'all something funny. Barry made me watch myself on this video camera, what y'all seeing on YouTube. And there was something I was teaching. I went, "Rare, it's done!" And I was like, "Oh my God, erase that." It's for emphasis when I act weird. Executed means it's completely done, guys. It's closed out. It's complete. An executed contract is closed. Executory is when you drive by and see signs that say under contract. It's pending. There's work to be done. And then you looked at your chart about valid, void, voidable. And so if you look on 261, the valid contract has all of the essential elements. The void is missing one, right? You know it's void at the beginning. And voidable could be avoided by one of the parties. If you get a test question and it says, excuse me, the buyer or the seller has been declared incompetent, the contract's void. If it says declared, or there's a word called adjudicated, it's a law word. Adjudicated means a judge has declared them incompetent or insane. The contract is void. So that could happen after the fact. Intoxicated, under duress, a minor who slipped into this contract, it is voidable. Unenforceable contracts are the oral contracts. You know, now oral contracts could go through. Don't you think back in the day people would sell on a handshake and their word? I mean, those things can go through. But for our purposes, we know mutual agreement means signed and communicated. Let's go over to page 262. Requirement of reality of consent. Reality of consent is another way to say mutual agreement. What if a buyer makes an offer on a property and the MLS sheet said 2,300 square feet and the house is listed for $200,000? Buyer makes an offer with knowing that information. The offer is accepted and is communicated, and the buyer goes to the bank to apply for a loan. And the lender hires an appraiser. The appraiser goes out to look at the property, and he comes back to the bank, because that's who hired him, and comes back to the bank and says, it did not appraise for $200,000, and one big reason is the square footage is not 2,300. The square footage is 2,100. Guys, there's a mistake there, isn't there? The buyer, that we don't have mutual agreement anymore because the buyer didn't agree to buy it for 2,100 square feet. He made his offer based on the information that he had. And so we could put this in a voidable category where the buyer can say, you know what, it was misrepresented. I thought I was making an offer on 2,300. And oftentimes, the seller and buyer negotiate that out. The seller will come down on the price, or the buyer can say, but I love your house anyway, I'll pay it. Or the buyer could say, I don't want to buy it because there was a mistake. That's not what I agreed to. Everybody good? Revocation of an offer, didn't we say that? We already talked about that, didn't we? Any offer That means a counteroffer, that means an accepted offer. Any offer can be withdrawn any time before it is communicated. Any offer. And so on 263, we looked at all of that. Agreement in writing and signed, didn't we talk about the statute of frauds already? According to the statute of frauds, you've got to have these, anything that's transferring a real estate interest needs to be in writing. Go with me to the very last paragraph on 263. I mentioned to you, and let me just look here for a minute. Go down to your 5th line on your last paragraph, 263. A listing agreement or a buyer representation agreement is an employment agreement and is not covered under the North Carolina statute of frauds. So it's not the statute of frauds that says put these agreements in writing, it's your commission rule. Remember I mentioned that to you earlier? That could be a test question, and that's a little bit confusing. According to the statute of frauds, which of the following contracts need to be in writing to be enforceable? If you've got a choice of a listing agreement or a buyer agency agreement, that's not according to statute of frauds. Are y'all following? That's a commission rule. All righty. Let's go over to page 264. When we talk about the parole evidence rule, parole is a word that means words. Evidence is put those words in evidence by having it in writing. The parole evidence rule, here's the way I'm going to say it. The last written word is what is going to overrule, or will be what is ruled. So in other words, if an offer comes in and the seller says, I want just a little bit more, and they cross out the offer price and change the price, that's called a pen and ink counter offer. We're going to want them to initial that and date it. Well, then what they changed is the last written word. That's what is going to be the deal. Is everybody with me? Think about offers that come in with an addendum. With an addendum like a backup contract addendum or a short sale addendum, that addendum changes some things in the original document, doesn't it? So the last written word makes the rule. Let me give you another example. Seller and buyer are in a sales contract, so they've agreed. Buyer wants to go out and look at the house. They just want to measure for curtains, draperies, same thing, furniture. They want to do that. So the buyer's agent calls the listing firm and says, could we go today at 2? And the firm says yes. The seller said they would be there. And if I would say to you they should not be, does that make sense?
That they shouldn't be there?
I don't think they should be there.
No,
Does
they
that make
shouldn't.
sense?
Yeah.
Why?
But they're gonna start asking silly questions.
Because people, they could say something, we're not closed out yet, are we? So maybe they shouldn't be there, or maybe their agent ought to be there with them. Guys, it's not done until it's done, right? So here's an example. Seller's there, buyer's agent and the buyer are there, and the seller says to these two people, you know, when we were negotiating, I didn't know where we were gonna move, so I didn't leave the refrigerator in the contract because it's personal property. We figured we'd take it with us, but we'll leave the refrigerator because we found a house that has one. We'll leave it. Buyer's happy, buyer's agent's happy, and they go finish walking around the house. We go to we're headed toward closing. That buyer and buyer's agent go do their final walkthrough on the property, and the refrigerator's not there, and there's nothing they can do about it because it was not put in writing. Let's rewind. Seller says, I'll leave the refrigerator after all. I'm going to say, my broker in charge will kill me if I don't have you put that in writing. Because the reason I'm saying it that way, if you say, and maybe I'm wrong on this, if you say we need to put that in writing, it almost sounds like we don't trust you and we need to put it in writing. We really need it in writing because we probably don't, but it sounds that way, doesn't it? And to make it kind of not look that way, my broker in charge says we've got to have everything in writing. Do you mind writing that down? Guys, they could write it on a piece of paper. I'm leaving this refrigerator, this side by side, this whatever GE, whatever it is, and the seller can sign it and the buyer can sign it and we can put it in our file, right? we're probably not gonna go back and change the contract, you're not. So it just needs to be in writing, and that would be the last written word then. Look at the bottom of page, the middle, performance of contract. This is bringing up time is of the essence. What does time is of the essence mean?
Have to be done by this date.
It has to be done by this date or what?
There's nothing.
Or it's breach. It has to be done by this date, or whoever doesn't meet that date is in breach. Time is of the essence is really legalese. I've never written those words on any offer that I've written up, or, filled in the blanks. I've never written those words. If a buyer says to you, I want time is of the essence on my closing, I'm gonna say, well, tell me why you want that. Well, we gotta be in by that date. Well, but if it was a day before or a day after, is that okay? Well, yeah, but we wanna be in by that date. Well, we probably shouldn't put time is of the essence. And we're gonna look at the contract Wednesday. If we put time is of the essence on the closing date line, it contradicts something that's in the contract already. Because the contract says there's a delay. We got a delay if it happens. Time is of the essence is usually on things where it is that important, like money's coming in. Time is of the essence is on the due diligence line. This date ends on, your time to inspect the house ends on this date. So it is pre-printed in about 3 different cases, but probably not something that you and I would want to write. If you can take a 5-minute stretch break, our day is really getting by fast, I think. Take 5 minutes and we'll come back and finish what we can. And then I want to give you your homework for this whole week.